Hi, everyone. I just want to take a few minutes to explain what you need to do to complete this week's critical thinking issue assignment. Right? Go ahead and bring it up here. Okay. So first things first, it's going to be very helpful to have gone through chapter 1 in order to complete this assignment. But also, you're going to want to go through all of this background information before you start answering the questions. Now, this assignment comes from the end of chapter 1. Every chapter in our book ends with a critical thinking issue. All right, and so we are going to address chapter 1's critical thinking issue this week. All right, so you'll want to go through chapter 1, and then when you get to the end of the chapter, you'll see, a little bit about the Alan Backey case and the Grutter versus Bollinger case. And then, here in our questions, it said, read Wrong Take on Admissions by Nancy Tanner on page 33. You will be reading things from the textbook as well, from the critical thinking issue section at the end of chapter 1. But there's some comments made or some things that are referred to in the intro to this critical thinking issue section that I thought deserved a little more explanation. All right. So here's the background information. And the issue this week here at the end of chapter 1 is on affirmative action in college admission. Okay. So affirmative action involves taking positive steps in job hiring and college admission to correct certain past injustices against groups such as minorities and women. So in 1954, the Supreme Court ruled in Brown versus Board of Education that school segregation was unconstitutional and that Black children have a right to equal education opportunities. The first affirmative action legislation was proposed by Vice President Richard Nixon in 1959, and affirmative action programs and legislation were expanded during the Civil Rights era in the 1960s. So, you're going to be reading 2 articles about affirmative action in college admission. They both kind of refer back to a couple of landmark Supreme Court cases. And neither article goes into a lot of detail about those cases because they're assuming that, because it's somewhat current or whatever, that the readers are already aware. But we aren't necessarily aware. So I wanted to give a little bit more background information than what is provided in that section at the end of chapter 1, right? So the first thing I want to do is talk about the Regents of the University of California versus Backey. Okay, so in 1978, Alan Backey, a white man, sued the University of California at Davis Medical School because his application was rejected while minority students with lower test scores were admitted. Notably, because UC Davis Medical School, their admissions process involved a special program to include more minorities in each new class of students. Now, an initiative to include more minorities in every incoming class, on the surface, that is not a bad thing, right? It doesn't sound like a bad thing. However, what UC Davis Medical School did was they had a committee that was used to screen the applications and select the 100 most deserving applicants. For each class of 100 spots, though, 16 of those spots were reserved specifically for minority applicants. So on your application, you could designate, yes, I am a minority. I would like to be considered for one of these 16 special spots, right? Or you could not designate yourself as a minority and compete for any of the 100 spots available. However, a white student could only apply for the remaining 84 spots. They could not, they would not be considered at all for those 16 spots reserved for minority applicants, right? So white students, they only had a 1 in 84 shot. Minority students, they could go for a 1 in 16 shot or a 1 in 100 shot. Like they could go either way, right? So as this essentially meant that a white student could only hope for 1 out of the 84 spots not designated for minorities, but the minorities could compete for any of the spots, right? Now, this also meant that a student receiving 1 of the 16 reserved spots, or even all of the students receiving the 16 reserved spots, could be far less qualified than the applicants who get rejected, right? Who were not minority, who didn't make the cut for the remaining 84 spots. Yeah, so you have 100 students who are not minority students competing for 84 spots. However many of those students do not get in those 84 spots, they could still be more qualified and deserving than the students who got the 16 spots reserved for minority applicants, right? So this is the underlying issue of the Regents of University of California versus Bakke. Alan Bakke had already been denied entrance to 2 other schools because of his age. He'd already been discriminated against because of his age. And then had been denied again at UC Davis Medical School because of his race. He claimed that the university's special program reserving 16 spots for possibly less qualified persons was unconstitutional and was reverse discrimination. So when he made his case in front of the Supreme Court, he won. The Supreme Court ruled that it was indeed a violation of constitutional rights for a school to use quotas as a means of accepting and/or denying college admissions. The court was not unanimous, though, and Justice Lewis Powell cast the deciding vote. Powell and 4 of the other justices ruled that any racial quota system supported by the government violated the Civil Rights Act of 1964. Any quota system for any race was a violation of the Civil Rights Act. So what UC Davis Medical School was doing, having those 16 spots, 16 out of 100, was a quota system. They ruled that that was in fact unconstitutional. It was against the law. However, Justice Powell and the other 4 Supreme Court justices, they also contended, though, that the use of race as a criteria for admission was okay. It was permissible. And they referred specifically to a system used by Harvard University at the time. So Harvard was a university that did not rely on any kind of quotas. They weren't looking for a specific number, right? But instead, they just actively recruited minorities. They sought to include minorities as part of each incoming class. So, of course, in the admissions process, they were looking at race as one factor in terms of who got admitted. So the Supreme Court here in the Bakke case said, that's okay. Like, we want a racially diverse, we want diversity on campuses. It is a state interest, right? Because remember, Civil Rights Act, any government-funded program cannot violate someone's civil rights, right? Unless there's a reason. And so the Supreme Court justices, these 5, were saying, it is a good thing to, try to increase diversity. That is a good thing for the school. That is a good thing for the students. That is a good thing for the workforce. That is a good thing for our country at large. But you cannot use a quota system. It discriminates, right? So Bakke won his case. He was admitted to UC Davis Medical School, but his case kind of became sort of the earmark for which all other discrimination cases for college admissions was sort of held up against. If it's a quota system, clearly it is a violation of constitutional rights, a violation of Civil Rights Act. But if the school is using race as just one factor, then that's permissible because we want diversity. So in the early 2000s, Barbara Grutter, who was a Michigan resident with a high GPA and high LSAT score, she was denied entry into the University of Michigan Law School, and she sued the university's president, Lee Bollinger, stating that the school discriminated against her on the basis of race, which is a violation of the Civil Rights Act. She claimed that the law school uses race as a predominant factor during the admissions process and gives applicants of certain minority groups preferential treatment during the admissions process. She felt like the school denied her application because she was white, and the school was purposefully admitting less qualified applicants solely based on their minority status. The law school did admit that they do take race and minority status into consideration, and they even award points, for different factors of an applicant's or a prospective student's whole being. But the school countered that it wasn't unconstitutional because race and minority status was just one of many areas that the applicants were scored in. There were plenty of other areas that had nothing to do with race or minority status. So, if she was denied admission, it's because she also didn't score high enough in those other areas, not just because she was white. And in June 2003, the Supreme Court ruled in favor of the University of Michigan Law School and Lee Bollinger. Justice Sandra Day O'Connor was the justice who wrote the ruling, and the court said that the law school's tailored use of race in the admissions process was not unconstitutional, that using race as one of many factors was in the law school's best interest in obtaining a critical mass of minority students, and that the law school and society at large benefit from a diverse student body. This means even a federally funded program, such as a university, is not violating the 14th Amendment if the consideration of race is one of many factors, passes scrutiny, and shows a constitutional right may be infringed upon if it is necessary to achieve a compelling or overriding state interest. Since the need for diversity on college campus has been considered a compelling or overriding state interest, then it is permissible to be used and does not violate the Civil Rights Act. Right? There are other elements to the court's ruling in the Michigan Law School case what you'll read from the textbook actually does do a pretty good job of explaining the other elements. But I wanted to give you at least some background here. So the first case here, the Regents University of California versus Bakke, because the first article you're going to read mentions that case. Then I wanted to give you a little bit of background information on this one, Grutter versus Bollinger, because both articles, they also mention this case. So having a little bit more information about both of those court cases can help you understand the two articles you're actually going to read. Okay? And feel free to do more research on both of those if you feel like it. Pretty interesting stuff. But what you're actually going to do for this assignment, under question. First, read Wrong Take on Admissions by Nancy Cantor on page 33 and answer these 4 questions. According to Cantor, how does affirmative action benefit both white students and students of color? According to Cantor, or what does Cantor mean when she says that college admission should be race conscious? Again, that's going to refer back up here to the Bakke case and what Justice Powell said. What is President Bush at the time? What was President Bush's stand on affirmative action? And why does Cantor disagree with him? That's mentioned in the article that you'll read, what his stance was. Okay, why does Cantor disagree with him? And then how does Cantor use the Supreme Court's rulings to bolster her argument for affirmative action in college admission? Okay, Next, you're going to then read the other article, Achieving Diversity on Campus, which is the majority ruling written by Sandra Day O'Connor, Justice Sandra Day O'Connor. It's on pages 34 and 35. First, why did Greta maintain that she had been treated unfairly by the University of Michigan Law School? What is Justice Powell's opinion in the Bakke case considered to be a landmark decision regarding college admission? O'Connor talks about that as well. On what grounds did the Supreme Court argue that attaining a diverse student body is an important part of an institution's mission? O'Connor goes into that too, all the reasons why having a diverse student body benefits the school, society, everything. And then what conditions and rough time limitations did the court place on using race in college admission? So this idea that like, it's okay for now because we need the diversity, but our hope is that this happens. O'Connor talks about that. Question 3. After reading both selections from the Critical Thinking Issue section, answer the following. Compare and contrast the arguments used by Nancy Cantor and the U.S. Supreme Court Justice Sandra Day O'Connor regarding the use of affirmative action in college admission. Which person makes the best argument? Support your answer. They're both arguing in favor of it. So we're not reading two opposing points of view here. They're both saying that, you know, these schools were in the right, at least partly in the right, for using race as part of their admissions process. But Cantor says it was right for these reasons. O'Connor says it was okay for these reasons. Compare and contrast their arguments, and which one do you think made the better argument? And then question 4, based on what you have read about these cases, discuss whether affirmative action has a place in a democracy that is built on equal rights for all citizens, or if it is a violation of the fundamental principle of fairness. And again, you feel free to research a little bit more about affirmative action in college admissions if you want. But you can also just read the 2 articles and the background information I've provided here and answer all of these questions. You'll do this in a file format. So Word doc, Google Doc, Open Doc, PDF. Easiest thing would be to use the file that I've attached to the instructions. Use that as your template. Type in your answer, save it, upload it. But again, the only file format that I seem to have issues with is the .pages format. So please keep that in mind. Reach out if you have questions. Otherwise, this is due Sunday night by 11:59 p.m. If you run into any issues or have any questions, please don't hesitate to reach out.